Hey everybody, good morning. I'm JD Houvener and welcome to the Bold Today show. I'm the owner here and founder at Bold Patents Law Firm, and I'm here with you most every Wednesday. I just took 2 weeks off down in Cabo, Mexico with the family on a family trip. So if you missed us last 2 weeks, we're here and I plan to be here every Wednesday going forward. So join us on the live session. If you're watching this after the fact, I'd love to have you guys on. This is going to be a discussion about patent law, okay, first and foremost, but I want to welcome business owners, entrepreneurs, of course, inventors, anybody who's really thinking about starting, a new project and wants to start a new company or a new technology. And they got questions about, is this something that's eligible? What's the difference between a provisional and a non-provisional patent application? So that's what we're going to talk about today as our main topic. So you've come to the right place to ask any question you've got about the process in general, but please do hold those confidential questions about your specific invention. This is a public forum, so I don't want you to have an early disclosure, right, about what your patent is about, what your invention is, because that would not be, under the non-disclosure agreement, right? This is not. I'm not your attorney. This is not, a protected broadcast. Okay, so we got the legal notice up there. If you do want to get started and you feel like, maybe after listening or right now you're ready to get started and see if you've got an invention that's worthy of moving forward, I'm going to reward you for taking action. So please follow this link right here. You'll see that the calendly.com link. And if you do that, take action. I'll give you a copy of this book behind me that I wrote, Bold Ideas, The Inventor's Guide to Patents. You'll get a PDF download copy of this. And actually, I just published a second edition. So you're going to get the second edition, not this older one, which has got some cool new examples. I use a dental office to kind of go through what an invention is like for a service company, as well as one that makes good. So it'll be it's a nice refresh to that book. Okay. The order of operations here is I've kind of done the initial introduction. I've got the book offer out there. So for those of you who want to take action, schedule a 15-minute screening session with our advisors to see if now is the right time for you. That's the link there. Next up is going to be the topic of the day, which is provisional applications versus non-provisional. And so some of you may have heard about these, right? You may watch Shark Tank or hear in the news or talk with friends or family about filing an application. And that is what this is all about, right? Getting a patent requires you to apply. You have to apply for the ability to get a patent granted. So when you apply for that, you're putting in your specification. You have to tell the government and tell the world, eventually it will be published, how to make and use your invention. In that application, you then will have to claim, or you have to claim and say, I have invented this specific thing, and here's the language about what I've created. And so that language is super important, and that's what the examiners will look at and say, has this inventor really done this for the first time? And is this a non-obvious version of something else that's ever come before? And so all that work that goes into writing and describing how your invention works and supporting those claims in the specification, that's the art of writing a patent application that will provide you, the benefit and allow the examiner to do a good search and to hopefully confirm that what you've got is new and non-obvious. So there's two different types of application. What I've described just now is the regular, the non-provisional application. What the Patent Office has done, and this goes back years and years, they've provided a provisional, sort of an informal version of that application that will still benefit the inventor. And it's a wonderful thing. It's called the provisional patent application. And it allows an inventor to, without having to go through the effort of meeting all the drawing requirements, all the specification requirements of having an abstract, a detailed description of drawings, all these certain specific areas of the application. The drawings themselves can be informal. They can be sketches. They can even be photographs. But you've got to still have your invention enabled, right? You have to still describe your invention such that someone could go build it. So that's sort of the threshold and what's required with the provisional. And what it does is it locks in that date, right? The date that you file that provisional, no one else in the world, if you were the first one to file it, will get rights over you, okay? So it is really important, that priority date, because that will allow you then to claim priority back to that first date when you do file your formal non-provisional application. So in the U.S., and most countries that have signed on to Modern Patent Cooperation Treaty Act, they give a full 1 year, right? 12 months to the date, hard deadline on when that non-provisional must be filed from the provisional filing date. So let's say you file the provisional January 1st, 2022. That means you must file that non-provisional 1 year later, January 1st, 2023. Don't miss that date, right? That is a huge, huge date. So you want to get started on the non-provisional generally about 9 months, right, after filing that first provisional, to give yourself 2 to 3 months of leeway to kind of build up and develop that additional detail, roll up some of the additional findings. And that's an important subject I'll probably bring up here next into the non-provisional. Okay, so one of the beauties of having a provisional is you get to say legally you are patent pending. This is huge, right? Very important aspect of what can be marketing, but certainly part of your developing your intellectual property assets. And when you can put patent pending on a product or on your website, on a service, it means a lot, and it really differentiates you from the competition. Now, as soon as you become patent pending, we advise clients different ways depending on what their goals are. But one of the most exciting avenues, if you're actually going to be developing a product and you want to be out in the market selling, maybe you're starting a company, raising money for it, you should start selling your product, making it and selling it. Now, those two processes of prototyping and making the product, there's a lot of learning that happens. And I hear that a lot from our inventors and our product developers that we have our inventors work with, is that there's iterations, right? As soon as you start building the thing you've got on your head or on paper, then you realize that, hey, that actually can't be manufactured quite so simply. We need to make a few modifications. The whole, the tolerances, right? The types of materials all change. And so all that learning that you do when you develop and manufacture your product, that's what you can do after filing the provisional. And then you get to roll up all of those changes, those findings, into the non-provisional to add more detail and to help you draft better claims. So if you had drafted the full formal application before doing some of that manufacturing and iterating, you might not be able to have that strong of a claim set, and you might not be able to get exactly what you're going to be going to market with. So of course there's manufacturing, and then once you start selling, don't forget about getting that feedback loop with your customers. Some of your first customers, maybe you're doing a freemium version if it's an app, or maybe you're doing a very discounted just to get the product out. You want to get their feedback. So stay in the loop. Don't just sell it and forget it. Say, hey, how's it going? Is it working the way you thought? If you could make any changes, what would you do? Right? And so you can start thinking about during that year how you might be able to add detail, how you can think of other versions, other adaptations to make your product more marketable, right? Be more successful, because you don't want to end up with a patent that isn't something that you can sell, right? So you want to, that's the benefit of using the provisional, that 1 year time frame to your benefit. So like I said before, the non-provisional must be filed within a year after the initial provisional. And the rigor of going through that, actually what the steps are of the formality, I'm going to save for another session. And what I might do actually is provide you a link to an article I wrote, an in-depth article, provisional, non-provisional difference, right in this link. So if you want to kind of dive in and go into this in more detail, we can. I wrote that just about a year ago. And there I actually go through some examples on what the statutory bars, knowing when to file, and I have got a cool little chart here. I might show. Yeah, and let me share my screen here really quickly. I'll look at that. Hey Flavio, yeah, thanks for that. I appreciate it. Glad to have you. Haven't seen you in a couple of weeks. Nice to be back after vacation for sure. Let's see here. So I got I'll just share screen briefly. Okay. So if you can see that we get the PPA versus NPA comparison table. The formatting on the table isn't perfect, but it's still going to get the point across. So the PPA here is in column 1. That's the provisional patent application, and the non-provisional is over here. So it requires patent research. Okay, it's super important here. They both do, and it's a great thought. You don't just want to file your provisional blindly without doing any patent research. So yeah, it's still required. And in many cases, if you hadn't done a search prior, and this happens a lot, we get a lot of inventors that find us when they're getting ready to do their non-provisional, but they've already filed the PPA on their own. We say, before we, what could be wasting your money and filing a non-provisional, we really need to make sure we do that search first. And so we'll do that search, confirm that what they wrote up on their application is new and non-obvious. And if it is, great, we'll help them prepare the NPA. But if not, we'll help them rework it and hopefully get to a point where we can still file it after making tweaks. So the amount of effort is about double for the non-provisional. I mean, just in terms of drafting the spec with all the formalities, the drawings, and of course the claims. So this is how long it takes our team to get this done at a world-class level. At the provisional is 4 to 6 weeks, and a non-provisional is 8 to 12 weeks. So years of pendency, like I said, up to 1 year. Do not go over. Must not go more than 1 year. That is it. So that is the entire duration of when your patent can be pending under a provisional patent application. For non-provisional, there really is no limit. We have had just a couple in our almost 10 years now of doing this that have gone close to 4 years, but most are within 1, 2, maybe close to 3 years in terms of after filing the non-provisional, going through the examination process and going back and forth with the examiner. Fee-wise, because there's lots of ranges, lots of complexity to think about. The most simple inventions on the provisional side, we're talking a couple grand. The most complex up to 10 grand. On the non-provisional side, it's about double, right? It's twice the amount of work, it's twice the cost. And so you can see that reflected here. Then the patent office itself will charge different fees for the actual filing. So the examiners can get paid for doing their research and their examination. So that's the fees you pay to the patent office separate from the attorney fees. So I want to show that little chart that was useful. But again, I put that link in there. You've got, this is the full link to the article. I go through the differences there, comparing the different requirements, all the different specs. These different links here show you what's required, the background, the brief summary, and that formal NPA, and go through some of the fees with you as well. All right. Well, I'll stop sharing here. Welcome, Bipol. I appreciate you joining us. And feel free to anybody with live questions. I will take those first. We're getting close to our session where we're going to jump to our avo.com questions. That's how we had a whole batch of trademark questions. And I'm happy to see we have our in-house trademark attorney, Matt Colseth, backstage. So I'll be getting to him in just a minute. So any of you who have questions on what we just talked about with provisional versus non-provisional, put those in the comments. I will get to those. I know there's sometimes a 1 or 2 minute delay from when you submit the question from when we can see it live. So don't be shy to put that in. And I'll put this in here as well. If you have additional follow-up questions for me personally, I always do my best to get back to you. So feel free to email me at jd@boldip.com, and feel free to do a text only to that 206 number. I'll get back to you usually within one or 2 business days. All right. So Matt, I see you backstage, sir. How are you?
I'm good, JD. How are you doing?
I'm good, man. Made it back from Mexico.
Good for you.
Yeah, it was great. Refreshing. Bringing kids, flying overseas, with 3 kids under 6. It was a bit of work, but we did get to that point where we found our rhythm, by the pool and they were cousins and everything. So it was great.
We're going down to Tulum here in a couple of weeks with the kids again. 8 and 5.
Good.
Traveling with kids on vacation, not as a vacation so much as it's just a trip. So
yeah, I hear that. Very good. Well, I see it. Xavier asked a question here. Maybe we can get to this really quickly before we do the trademark stuff. What's an average price for filing a provisional patent application? Good question. I try to give straightforward answers. When you before filing, as I said before, you should do patent research. So if you include the search, you can expect anywhere between $6,000 to $10,000, all right, to do it right, to do it at the world-class level. Now, that doesn't mean you're going to have to pay that all at once. Like I said, the search comes first, and so doing the effort in terms of searching for patent, non-patent literature, and then the application. So you'll be expecting, anywhere between $6,000 to $10,000 to get that application submitted, working with our firm. So thanks for that question, Matt. Let's do trademarks. So as I said, we had 9 questions. We're going to do a blitz.
All right.
Yeah, and then this is Avo. So we're going to get, and I like surprising you too, because it's almost more fun that way. So this is out of this question's out of LA. I'm going to throw this up here. Oh, this is like a multi-part question. You can just tell me this is way too detailed. So that's okay. I like it. So I'll put it up here. and then we'll pop it up on the screen. We'll probably cover our faces because the question is so long. Goodness, this is thoughtful. Okay, here we go. Whoa. Oh, here it is. Okay. Are my business names okay to use? And is it okay? I love it. Okay to use different LLC and domain names. I'm looking at two names. This is for a general brand name that will cover anything I want to do in the future. Number one is no active marks in my class, but some non-English marks in exactforeign.com. More spot on to the brand personality. Number two has a bunch of active marks in the other fields with other word marks. And one or two mark has a huge company in the same class. So he goes on, but do you want to take on kind of those first couple parts?
Yes. So with regard to using your business name as a trademark, I mean, certainly you can. A lot of clients will have their LLC named the same thing as their trademark, right? So think of your business entity as just that. It's a legal entity. It is not necessarily a trademark. You could be Bold IP, PLLC, and have a different brand name for your consumer-facing services or products. So you can have an LLC name one thing and your trademark be something specifically different. You don't need to register your LLC. And as a matter of fact, we can't necessarily register LLCs as trademarks because an LLC is a business entity. It's not a trademark. And now a portion of that business name could be a trademark as well. With regard to the question around domains versus trademark registrations and which is more important, if you have two in mind, when I've been doing this now for 10 years, and 10 years ago, I would say that your domain was really important from a search engine optimization standpoint. It's just not the case anymore where your domain is as important as it used to be. So if you have to choose between registering a trademark and getting a domain, I mean, 99% of the time, it makes more sense to register that registrable trademark as opposed to going with an unregisterable name only because you can get the domain. Now, ideally, you get both, but it's so uncommon today for clients to get their trademark registered as a trademark and also be able to register that with the domain services. So,
cool. Awesome.
Register.
Yeah. But there's a third part of this question. I like it. There's a money expert. A money expert says to pick a favorable NAICS code for the business. Any inside classifications? Any sub inside the classification?
Ooh, interesting. So NAICS codes. Obviously that's part of your LLC or corporation registration process. It really has nothing to do with your trademark registration. When we register your trademark at the USPTO, we're gonna pick from 45 different classes of goods and services. They don't follow NAICS codes, right? There's some overlap, obviously, but your NAICS codes are really to give your state a better indication of what services the state's providing, right? Or what products the state is providing. It has nothing to do with your trademark registration status or application. So I wouldn't necessarily consider that in the context of trademark registration.
Got it. Matt, you're on fire. That's awesome. Okay, we got one. This is about podcasts, so it's kind of similar to what we're doing here. Let me put this in. All right. Okay, so can I keep the name of my podcast, even though it contains well-known science fiction names? I'm guessing, and I have a podcast that's named after two very well-known planets within the science fiction world that were popularized by two very large companies. I did some research, and one name has several standard character trademarks associated with it, and other doesn't have any trademarks at all. Is it okay that I'm using these names in the title of my podcast?
Good question, right? So I actually dealt with this in the context of video games not too long ago. We had a client who was using a related name to a very popular video game, right? And so this question is familiar to me. The answer is it depends on how closely related that name is to the services that company provides today. If it's what you're doing is what's called a suggestive trademark. You're taking a name that is basically a coined name from a third party, and you're using it in a suggestive way for your podcast, which is good trademark use. The problem is that name is probably a coined name, right? And so it's highly unlikely that anyone's going to assume that you created that name, whole cloth. The question then becomes, is it feasible that consumers, listeners to the podcast are going to think that your podcast is in some way affiliated with that third party? And if the answer is yes, then you're going to have a likelihood of confusion potentially between your podcast and that registered brand. Now, the USPTO is not going to deny your trademark registration unless that third party has also registered that brand with the USPTO. But you may get an issue or pushback from the third party's attorneys who might be searching that particular name in their quarterly trademark search. So I would advise you to give me a call so we can talk a little bit more about it, because it seems like a jump ball. Could go either way.
Good stuff. Good stuff. Thank you. All right. Yeah, I wonder what that planet name is.
Yeah.
All right, here we go. So how safe am I? This is related to a nonprofit and a trademark question.
Great.
This may be good. Kind of
Sure.
bringing in
Love it.
all areas of commerce and business. Absolutely.
Yep.
You've worked with some nonprofits, haven't you, Matt?
Oh yeah, we do it all the time. So yeah.
So recently registered a nonprofit and applied for a trademark on the name, but I've to wait until February to hear the decision. Am I safe to operate it and basically use the name, or should I wait until I know the name and logo or trademark registered? Well, probably unlikely. I don't want someone to use my name and logo and get away with it because it's not a trademark, or worse, do it themselves. Please help.
Really good question. So what it seems like the individual has done here is file what's called an intent to use application, which is kind of like a patent pending, trademark pending application, meaning that you're putting it in for an application, you're not using the trademark yet, but you're going to be. And what you're asking for is the USPTO to give you some preliminary protection until you go to market. And you're also waiting to get preliminary approval from the USPTO so that when you do go to market, you're basically guaranteed registration. What I would say is that when we do the world-class search, as you kind of mentioned earlier, JD, we're basically more or less going to be guaranteeing our clients the ability to register that trademark. That's what we strive to do. We can't always do it, but the goal really is to give the client some certainty that we can register the trademark as we applied for. The nice thing about that is you don't have to wait for the USPTO to give you preliminary approval before you go to market. Oftentimes, clients now with COVID are waiting 5 to 6 months before we even hear back from the USPTO. It's a long time for a business to wait. So oftentimes our clients will go to market before the USPTO even gets back to us. But I never encourage clients to go that route unless we've done the proper search and opinion so that we can advise the client of their likelihood of whether or not they're going to register. Got it.
So it kind of sounds like, if you haven't done the search, you may not be so safe. And you're kind of, hopefully you've taken at least a look. And then if you've done it on your own, okay. But if you've hired a professional patent or trademark attorney, to do that search, you're even more safe. So that's the option we recommend. Cool. Let's do one more. I don't see any more live questions come in. We'll take those if you have them. And thanks again, Matt, for being on. This is great. You're doing good on these.
I'm JB. I love this.
Let's see if we can do that. Yeah, I wish we could somehow score you. This is like a game show thing. I'd love to do that. Oh man. Okay. This is a TV awards show. It kind of gets me going. Let's see if I haven't. I'm just scrolling through these. I should send these to you in advance, maybe. Right? That'd be a good idea.
Oh, absolutely.
If we can kind of pick and choose. Okay, so they want to use a speech from a TV awards show, maybe a copyright issue here, on clothing to sell. I'm trying to start a clothing brand and I resonated with the speech from an award show and a song. Can I use the speech on the clothing? What are we working with here? Yeah,
this is a copyright issue more than a trademark issue. So copyrights protect, works of art, whether it's a speech, music, works of art and, paintings, that sort of thing. Whereas trademarks are going to protect the source of the origin of the product or the service. So this feels more like a copyright issue than a trademark issue. And what I would say again, it would depend on the context of how much of that speech or song is being used. lifted from the original artist and taken and put on a t-shirt. Certainly, we can't copyright the whole English language, but if you're using a significant portion of the copyright work, yeah, you'd be in violation of the copyright, and somebody would have the opportunity to potentially come after you with Digital Millennium Copyright Act violation.
Yep,
something like
that. Absolutely. I think you hit the nail on the head. That's what I remember too for my copyright courses. I worked at an art clinic as well, and it was sort of, yeah, even if you're using, 3 or 4 seconds of that speech, if that's the big punch word or phrase that people remember, you're going to be infringing. Absolutely. So there's no necessarily amount or duration that's acceptable. It's just, would it be recognized? Would someone else recognize that you're in a way benefiting from someone else's creative work?
Correct.
Mark, we got a fellow client, Mark Osseller's on from Facebook. Am I able to expand trademark categories on an existing trademark, or do I need to start a new application in the new categories I'd like to cover?
Good question. So you would, assuming you have a registered trademark in one or more classes at the USPTO on file, we can't take your existing registration and simply expand it to multiple categories. Instead, what we would do is file a new trademark application citing to the registration that you already have. And that way, basically, we're saying, hey, we're such and such, we own this registration for these particular goods or services. We're now filing to expand into X categories. So it would be a separate application, but you would cite specifically to your prior registration.
And just when you do cite, does that help the examiner? Do you get any real benefit from that, or is it just kind of just linking them to help?
Definitely. Okay. So there's, in the 10 years I've been doing this, we've found some creative ways to apply for difficult trademarks. And, oftentimes what happens, well, not oftentimes, but it happens enough where we have a client that might be in 2 or 3 different classes of goods and services, and we know we're going to have a problem with 1 or 2 of those classes. And so what we'll often opt to do is advise the client to file in the easier to register class first. And then after it registers, go back and cite that prior registration as proof that we're now should be allowed to register in this new class. And that's a way that we can kind of help increase our odds of client registration at the end of the day. And that's ultimately what we're trying to do, is that, we can't guarantee registration success, but, I always tell clients, I'm in the business of registering your trademark, not applying for something that you're not going to get. So if we have to do a little bit more strategy and, register one class first and then piggyback on that registration, that's what we'll advise the client to do.
Yep. Very cool. Very cool. Well, I think we're wrapping up here, guys. We're just a couple minutes left. I'll reserve that time for any live questions we have. And thank you, Matt, again for coming on, for sure. So we want to hear from you, right? This is why we're here. So if you have any ideas in terms of what you want to hear about, topics, questions about products, maybe you've heard a recent article about a court decision you want to hear us discuss and go back and forth about, we're all ears. So again, thank you for tuning in live. I saw we had some good thumbs up and hearts even. That's great. Thank you. And we got some eyeballs. So this is good stuff. We'll be here every week. Matt and I are going to be tag teaming on patents and trademarks, and we're doing this again. So we'll see you next week. Have a great rest of your day. Go big, go bold.